As we are here on the Hinton versus Hinton, is that correct?
Yes, those are my motions.
All right. Either side wish to make an opening statement?
I think briefly it might help report a little bit. December. Last year, the divorce was filed. We got the additional paperwork done. There was an order of protection that was filed for in General Sessions Court. Ms. Roberts had filed a motion to consolidate that order of protection here. I did not get involved with Mr. Hinton until I think there might have been one or two temporary hearings. There was some spousal support, child support that was set before, and then maybe the order of protection is I know that day I was here. We agreed to the order of protection. There were some criminal charges that Mr. Hinton needed to kind of get through. He and I both felt like before we could do anything else. So we agreed to the order of protection. The kids are on the order of protection. These parties have children together. We summarily agreed to it, and I tell you with the thought that we can come back in and under the court's purview, modify that if things were going well with Mr. Hinton.
Go ahead.
So Mr. Hinton's gotten all down the road. The criminal charges are reset to be dismissed. He can testify he's got, I think, one class left of what he's supposed to be doing. And it's the holidays. He was prohibited from having any contact with his children. And we're asking for some holiday visitation. He's residing with his mother. And the children have spent time with the mother. She's here to testify if needed. And she would be a good supervisor if the court warranted supervised visitation to be able to see the kids on the holidays and get some visitation of the parenting plan that was filed by the mother. I was looking at it. It's the standard 88, 90 days, something like that, and holidays and things of that nature. I guess today we would ask for that to be adopted on a temporary basis, the parenting plan even by the mother, if we can do that, or do it supervised, or just to know that the kids are going to be at the home of the mother and that's where they're going to be during any of those times. And again, he hasn't seen the children in quite some time. Mr. Hinton has also had an accident with a motorcycle and a wet road. Either one of those, you're not going to win. He has messed up his knee. He is going to testify he is out of work for a period of time. He has a pretty good job. The court will look back through, and he's making pretty good money where he is. And one of the benefits is a short-term disability, and he has filed for that. His job has said that he's going to testify he's unable to work because he's required some physical activity. He can tell you what he's done to his knee in this process. It's going to have to heal up before he can go back. But it's going to be a little while. His short-term disability he's going to testify to will come in at 100%, and that's good. So his entire pay will come back at 100% at some point, and he thinks he's fairly close to getting it. There's an issue where it was set last time with all of his overtime, and he does work overtime a lot, things of that nature. And it should have been set with overtime. That's part of the rule. But at this point, if he does short-term disability, he's only going to be getting 100% of his pay without the overtime. And at the end of the day, we're going to ask the court maybe to set child support, revisit the spousal support at this point that he's been paying religiously, and his mother paid last month when he was out of work, and testify to that. That he's been paying, quite a bit. It's in excess of $2,000 a month in this process. So we're just asking for that to be maybe modified in the interim to fit what he's actually getting in as some income. And understandably, it's him on a motorcycle, but it was an accident, and he is going to be out of work for a while. Thankfully, he's got this short-term disability for everybody to fall back on whenever it does come into play. So that's basically the two motions that I filed in a nutshell.
Governor, if there's a matter of where Mr. Hinton comes before the court with unclean hands, this is one. Mr. Hinton, and again, I challenged the fact of where he's telling his lawyer where he lives. Mr. Hinton has left this family. There's an order of protection that's been extended for a year. The children were victims of an abusive relationship that he precipitated. He is living with a woman now. He may be, again, we all go in this case of where I live as opposed to where I stay. He has impregnated a woman while he's still married to my client. He was riding a motorcycle while intoxicated, had a wreck, did not call the police. There's no evidence of a motorcycle wreck because he didn't call, and there's no accident report. There's significant issues when we were before the court before. He is going, apparently he's worked out an agreement with the District Attorney General's office, wherein he is completing anger management and going to therapy. And he is supposed to finish that in November. It is not November. He has not completed that process. And so again, we are opposed to any modification of either a parenting plan or a modification of his earning ability. He has a $700 and some odd truck payment. He's bought a motorcycle where he's paying almost $300 a month for a motorcycle that he's out gallivanting on and apparently we don't know the facts and circumstances of the wreck because the man didn't call and make an accident report. Did not call. There's no police report. So again, we don't know how that's going to happen with his automobile insurance as to whether or not that's going to be covered on this marital asset that he apparently wrecked. I've not been provided any medical proof that he's unable to work. And again, we vehemently oppose any modification at this point in time. Again, if he fails to pay, it may come into the issue of whether or not he's willfully in contempt of court. But if somebody loses their job or is unable to work because of their own fault, it's our position and our argument, Your Honor, that that's not a basis to modify a court order.
Well, let me ask a question for clarification because the order was signed by Judge Larry Wallace back in January of this year. And in that, it makes reference to an order, ex parte order of protection, but apparently that's in a different file. And you may have consolidated them, but the order from January of 2024 states simply that the mother is designated as a primary residential parent and based on the proof offered of domestic abuse occurring in the home and in the presence of the children in the existing ex parte order of protection, the defendant father is afforded no residential time with the children. Now, having addressed that was Judge Wallace's ruling. I'm now being asked to modify that to grant some sort of visitation. Is your client opposing any form of visitation?
Yes, Your Honor, at this time, because the order of protection has since been extended, including the children. So there is an order of protection in place where he has no contact with the children. Of course, under the statute of the order of protection, if a divorce is filed, the court has the authority to modify it. But there was testimony back at the time that the children were victims. They were present during the assaults that took place, and witnessed it, and again had physical hands put on. So again, the order of protection is in place. There was an order that was done.
That order of protection through this court, I assume, since General Sessions does not do General Sessions. Can you pull that file from me? I'm going to ask the clerk to pull, but we'll go ahead and start the hearing. I want to have her pull that. Did I actually hear the order of protection, or do you know?
Well, what I recall, if I'm correct me as always, if I'm wrong, we came to court and we agreed to this with Judge Lockhart Mash on the bench with the thought, and I kind of said that from the announcement, was that maybe if he gets his things in order, we could come back and ask the court to relax this so he could maybe see his children and have that as kind of.
Well, I just wanted to know if there was some reference to extending the order of protection or having a hearing on an order of protection, and I'm trying to determine if I heard it. No. Sometimes I do, and I don't recall it, but this is not one that I recall.
These events transpired. We filed the order of protection, got an ex parte order got signed. It was set for hearing in February of February. We filed the divorce. We came to court on a temporary motion to adopt a parenting plan and to set support. That was in front of Judge Wallace. We put on proof, and the court entered that order. After that, Mr. Holly got involved in the case, and the order of protection came before the court. At that point in time, Mr. Hawley and I, both representing our clients, agreed to an extension of the order of protection. That's where, at that point in time, what was going back and forth is that there were criminal charges that were still pending. We had an issue where Mr. Hawley's client had these criminal charges, so he was reluctant to put him on the witness stand, given the fact that I was going to question him about the facts and circumstances with an ongoing criminal case. He has now gone back to General Sessions Court, and as I understand it, what Mr. Hawley has explained, he has worked out an agreement with the District Attorney General's office wherein if he completes anger management classes and goes to individual therapy, then those charges will be dismissed. It has been continued. I do not know the continuance date, but his therapy, based on what our conversation has been, his quote unquote anger management type therapy, or anger management portion of that is not to be completed. I think he has to go through November.
You know, one more class and we're going to
And so that won't be done.
second.
And so that's our basis, is that even the criminal case can't be dismissed. So he's still got criminal charges. He's going to take the witness stand. I'm going to question him about those criminal charges. And again, there's no written agreement, and my client hasn't signed off as the victim on a dismissal. But we were in front of Judge Lockhart Mash, and that order should have been on the form where it was extended.
Okay.
And I think that's the synopsis.
Well, and therein lies the answer to my question, was whether or not what the circumstances were and how it came to be that there was an order of protection, but it was not. It may have been consolidated, but it wasn't in this same.
After the fact, I asked to consolidate.
There was a motion to consolidate that's in your file, Auburn's file, and on that day we agreed to consolidate it, and I agreed to the order of protection with those caveats.
All right.
And again, and just to put on the record, again, I don't want anybody to be shortchanged because of my situation. As Your Honor knows, I am representing Judge Wallace. I am adverse to Judge Wallace's administrative assistant. She is going through a divorce, and I represent her husband. As a result of that, I had a telephone conference with Judge Wallace because he could very well be a witness in his administrative assistant's divorce case. And as a result of that, he has put down an order, and I understand he's notified the clerks that he will not hear any case that I'm involved in. So he advised me during a telephone conference that due to the fact that I may have to cross-examine him and his wife, that he is no longer hearing cases until Miss Valerie's divorce case is over with. So that would preclude them from going back in front of Judge
Well,
Wallace.
I'm not sending you back in front of anybody. I just wanted to make sure of what it is that I'm hearing, and had I heard anything in the case before. I don't care whether I've heard anything or not, or who has heard it. I just wanted to make clear on the record what my understanding of these facts was. So, all right, we're ready then, Mr. Hawley. You may put on your proof.
Mr. Henry.
And if you'll step around and raise your right hand. Raise your right hand, let's place you under the.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Hawley, you may ask. I'm going to ask you to speak loudly into that microphone, okay?
All right, state your name. All right, Mr. Henry. And you heard our opening statements. There was a divorce complaint filed against you in December of, last year, correct?
Yes, sir.
All right. And you guys came to court, it looks like then on January the 4th
Yes, sir.
of the next year, this year, 2024. And at that time, and I'm looking at the order, was there were you in court that day? Was there any testimony given on that day?
No, sir. And the fault lies on me. At the bottom of the paper, it was scribbled. The date was scribbled out and written over in pen, and I thought it was January 14th. So I was actually at work that day, so I missed the 4th.
Okay. Regardless of that, still, you never contest. We never asked to set this aside. You just went ahead and went with this order, correct?
Correct.
And in this order, it looks like you're ordered to pay $1,298 a month beginning in January of 2024 for temporary child support. Is that accurate? And what were you to pay in spousal support?
$1,050
And how often was that payment to be made?
once a month.
And have you made those payments?
Yes, sir.
Okay. Sitting here today, are you behind on any payments?
No, sir.
So where do you work?
Albemarle in Johnsonville.
I'm sorry, where?
Albemarle.
Albel-Meyer?
Yes, sir.
Okay. You spell that for the court report?
It's ALBEMARLE.
And what do they do there?
They make lithium products that go into rubbers, plastics, and pharmaceutical medicine.
Okay. And what do you do there when you're at work?
I'm an operator, a chemical operator.
Okay. Help us out a little bit. What does that entail?
So my job description really kind of depends on the day and what's needed. I can either be in the plant where we are making these products, or I can also be in shipping where we are loading trucks, unloading trucks, trying to get product out.
So does this job description of yours require any physical activity?
Yes, sir.
Explain to the court what type of physical activity your job description requires.
So it's a lot of walking up and down stairs, ladders, bending, twisting. You got to climb on top of trucks to get them hooked up to start loading. And my work is the one that decided that it was, better for me.
Objection, hearsay.
Well, he can testify as to why he's not at work, I would think. He didn't say what the worker said.
Well, you didn't ask, he wasn't about to testify about that. I mean, basically, he was about to say his work decided, so you may question him about it in a form that doesn't include hearsay, but sustain the objection as to the present action.
Okay. Are you allowed to work at your present condition?
No, sir.
Objection, Your Honor. Object to the form of the question, asking who's allowing what it is. It's asking for hearsay.
It's not actually an out-of-court statement, though. Hearsay is defined as a statement made outside of court that's introduced to prove the truth of the matter. What he's asking him is the reason why he hasn't been able to go back to work, or what the cause is. And overruled, I'm going to allow it.
So you've given your job description.
Yes, sir.
Tell the court, let's start with the accident that caused your injury.
Yes,
Tell the court about your accident. When was it? Start off with that and then tell the court what happened.
So I believe it was the 7th of September. Anyways, I was out riding with a friend, and him and I got stuck in the rain. We went to his house temporarily. The rain stopped, and me returning back, started a downpour again and poured into the driveway. There's a bunch of pine needle and stuff on the ground. And I was just about to park the bike too. It went to fall over, and when it went to fall over, my hand hit the throttle and it spun around in a circle, which ended up landing on my leg.
And you're saying the driveway, what driveway was that?
It was my girlfriend's driveway.
And what damage did that do to you personally, that accident?
So according to the orthopedic, they
And I'm
said,
going to object, Your Honor, it's proper medical diagnosis of what the orthopedist said.
I'm asking what his injuries were.
Well, yeah, you may be asking him what his injury was, but he's stating what the orthopedic said, and that's hearsay. Any individual can testify about injuries that they sustain, but they cannot quote what they're being told by a medical provider without it being hearsay.
Okay.
Sustain the objection.
Let's tell the court then, what are your injuries according to you?
my knee, it buckles and pops and cracks. That's what's led me to the out of work.
Are there any torn ligaments?
Uncertain.
So what was your answer?
Uncertain. I had an MRI October 8th, and they just called me yesterday for an appointment scheduled later today to go over those results from the MRI.
All right. But just to be clear, with your job description you just gave the court, can you fulfill that job description?
No, sir.
Do you have any benefits at work that would allow you to get paid during this time?
Yes, sir. We have short-term disability and long-term disability. Both of those company pay for. However, it's been a process trying to get that started.
So do you have any sort of expectation of getting any of those benefits?
Yes, sir.
If you were to receive your short-term disability, what would that mean to you?
So, for one, I'd be able to pay my child support or spousal support. So I don't come in content with court orders. That will allow me to have money, food, and so on.
How much would you receive?
It would be a 40-hour pay week, so it would be 80 hours on that check.
When your child support and spousal support was determined in January, was it determined with overtime?
Sir, I was not there. Well, I was not present during that day.
Right.
Show you a document, ask you if you recognize that document.
Yes, sir.
What is that document?
A expense report.
Does that accurately reflect your income on the front page?
Yes, sir.
And does that reflection of your income include any overtime?
No, sir.
If you received your short-term disability, would this be what you would be receiving?
Yes, sir.
And then your deductions are listed after that. On the next pages, what does that depict?
Necessary monthly expenses.
Did you list anything like for rent, mortgage, or anything of that nature?
No, sir.
So where are you staying or living at this time?
So I'm between my mother's house and staying with my girlfriend where I can. Obviously, paying the child support and spousal support has me less money, and unfortunately, my truck uses a lot of gas. So, I've been staying back and forth between those two places.
And at the end of the day, in your income and expense statement, do you have a negative figure?
Yes, sir.
But that's also including your child support, spousal support, correct?
Yes, sir.
What are you asking the court to do for the child support and the spousal support?
Well, I would like, if possible, to get it lowered, where I can still be able to pay for my truck and credit cards and just be able to live.
Well, are you behind on any other payments because of this?
Yes, sir.
Spousal support,
Yes, sir.
child support obligations?
Yes, sir.
What payments are you behind on?
I'm behind on 2 credit cards. I opted on 2 credit cards. I'm behind on my truck payment. There's something else I'm not really 100% sure what it was.
So the truck and the motorcycle, did you have that prior to the
Yes.
complaint being filed?
Yes, sir.
Was that a payment that was it's a marital payment, is that fair enough?
Yes, sir.
Let's talk about the children. When's the last time you saw your kids?
December 8th of last year.
And what are your kids' names and ages?
Stefan Henry Jr. and Gabriella Lucia. And TJ Stefan Jr. is 10 and Gabriella is 8.
And did you have a good relationship with your children before this started?
Absolutely.
Were you there or how often were you there with your children before this started in December of last year?
Yes, every day.
And, you were accused of having an affair,
Yes, sir.
and you've admitted that in the pleadings, have you not?
Yes, sir.
You don't really hid that, correct?
Perfect.
Have you done anything that would cause concern as far as you being able to see your children?
No, sir.
If the court were to allow some visitation, could you do that at your mother's?
Yes, sir.
Is she here to testify to that as well?
Yes, sir.
You've had a chance to look at your wife's parenting plan that she filed against you in December, correct?
I believe so.
Are you asking for the judge kind of to adopt that on a temporary basis?
Yes, sir.
And if he feels like it needs to be supervised, are you okay with supervision?
Yes, sir.
Let's get into the domestic charge. You were charged with domestic.
Perfect.
And specifically, what were you charged with? Anything else?
No, that was it.
So it was one domestic assault.
Yes, sir.
Is that what I'm hearing? And I didn't represent you with that, correct? You had another lawyer. And where was that being heard at?
Here.
Okay. Downstairs.
Yes, sir.
Was that a transfer from another venue?
I'm not 100% sure, to be honest.
Okay. So you hired a lawyer for that, and you came to court.
Yes, sir.
And tell the judge what the adjudication of that charge was.
I'm sorry.
What happened on that day when you went to court?
It was determined that if I finished my Banters class, anger management, no new charges, then we reserved the right to amend the order of protection and take the kids off and leave her on.
Your Honor, again, I'm going to object to whatever hearsay this may be.
Well,
I don't understand who the district attorney general has no authority on an order of protection.
Well, to that portion of his answer, I would sustain the objection, except that he can testify about what he understands the agreement was. But as far as quoting what we, and if that is to include what the state says, then I would sustain the objection. He can testify about what he understood the agreement was and what he agreed to.
my question deals with General Sessions downstairs and that domestic assault.
Yes, sir.
And specifically, what's your understanding of the agreement that you're following right now? And the domestic assault charge only now.
So it was no contact with her, third party. Like I said, no new charges, and I've got to finish those classes. I've got one more November 2nd. It'll be completed. And to my knowledge, that would allow visitation to start with the kids, or to have them amended on the order of protection.
All right. So you said something a minute ago. I want to clarify. You said batterers and anger management. Are you talking about one class, or are those two separate?
It's one class.
Okay. And where are you taking those?
Franklin, Tennessee.
Okay. And what's the name of the place that you're taking those at?
Choices.
Choices. Do you have one person that's giving you these classes, or is it in a group, or what?
I'm sorry, can you ask the question again?
How are you taking those classes?
It's an entire group of people.
But to be fair, now this was, when was this heard in General Sessions downstairs? Was it April of this year?
Yes, sir.
So if it was reset for 11 months and 29 days, how long will this go?
How long will the class go?
No, how long has this continued to be reset for?
It was, to my knowledge, it was total 1 year from that date.
Which would be April of just next year, correct? Before it got dismissed. And just to be crystal clear, these classes, your last one is done on the 2nd of next month.
Correct.
All right, have you got that down on your calendar?
Yes, sir.
You plan on making that class?
Absolutely.
How many classes have you been to before this one?
3.
How many?
3.
3 classes?
Yes, sir. Each one of them are about 11, 12 hours for each day that we're there.
11, 12-hour class days?
Yes, sir.
It's different. What do your children mean to you?
Everything.
Do you want to have some time with them on the holidays? Is that important to you?
Absolutely.
Will you abide by any orders that this judge puts down? Are
Absolutely.
you prepared to abide by that if you are granted any time with your children?
Yes, sir.
That's all I have.
Ms. Roberts, you may cross-examine.
You're aware and you were provided a copy of the order back in January that Judge Wallace entered, is that correct?
Yes, ma'am.
And you saw at that point in time, your income was calculated at $39.57 an hour. Mr. Holly asked you if your child support was based on any overtime. In fact, the order clearly reflects that you made $39.57 an hour, and that was what your child support was based on, a 40-hour week of $39.57, correct?
I suppose.
Well, it's in the order. Again, but then now you've submitted an income and expense statement. Was that made an exhibit to this hearing?
No.
In the income and expense statement that your attorney provided to me, you have income that reflects that you make, and you said it's a 40-hour week and you get paid bi-weekly, so it's an 80-hour check.
Yes, ma'am.
And if you calculate the money that you put down there, you're actually making $40.56, correct?
Yes, ma'am.
So your child support was based on about $1 less an hour than what you were actually making. Isn't that correct?
So we got a raise, and I'm not sure what month that took effect, but during that time frame, that was accurate.
But part of the benefit that you have at your employer is you have both short-term and long-term disability,
Yes, ma'am.
and that's 100% of your 40-hour week, which is your child support was based on $1 less an hour, correct?
Yes, ma'am.
And you get back pay. When you get approved, you get back pay.
Correct.
So whenever the last day that you work, sir, when you get your short-term disability that you've testified here under oath today that you're going to get, you're going to get your money back from the time that you didn't go to work after you had your wreck, correct?
Yes, ma'am.
So you're not going to have any change in your income, are you, sir? You don't have to look at Mr. Holly for the answer. You can answer it yourself.
I mean, I don't suppose.
You don't suppose. And you knew that before you filed this petition, this motion, and had us come in here today, correct?
So with having to pay this and to pay the stuff that I've already had, I've been having to work overtime when it's available for me to work.
So, but your child support and the alimony that we presented to the court when you didn't show up in January, even though you were served and had notice, she only calculated it on what she thought your hourly rate was $39.57. That is stated verbatim in that order, sir. So you've been actually making more money than that, correct?
I don't know when the raise went, what
No,
month
you
it
said
went
you-
into effect.
Apologize, I didn't mean to interrupt.
Oh, I'm sorry. So at the time that was put in, that was correct.
Okay, but you got about a little over $1, 99 cents an hour raise, and you've been working overtime, and your child support or your spousal support was not based on any overtime, was it, sir?
I'm unsure.
Beg pardon?
I'm unsure.
You're unsure? Your Honor, may I approach?
May.
Sir, I'm going to come over here beside you and read something to you.
Mr. Holly was asking what you're about to show.
The order, I'm sorry. There has further been a petition for an order, excuse me, okay, let me go back up here. Upon the call of the case, the defendant failed to appear, and upon sworn testimony of the plaintiff, the court finds that the defendant is gainfully employed at a rate of $39.75, but it's transposed, $39.75 per hour. And therefore, his monthly income is $6,890. And that's without any overtime, right?
Yes, ma'am.
The wife's average income is $2,560.
Yes, ma'am.
Okay. And those were true at the time. Is that right?
Correct.
And you were actually working overtime.
When it was available, yes, ma'am.
So this was in January of 2024. So in the whole year of 2023, you did work overtime.
When I could, yes, ma'am.
So your wife, when she came to court, did not present money about what you actually were making. She did it on your base salary, didn't she?
Yes, ma'am.
And this was the time where you left your family and were having an affair with your daughter's cheer coach, nonetheless, correct?
Correct.
And you've impregnated her,
Yes, ma'am.
and you're about to have another child with her.
Yes,
And when does that child due?
ma'am. February.
In February. So when you testified that the reason, and I may have misunderstood, don't have the best hearing, but you testified that I recall from Mr. Holly, yeah, I'd like to get this child support lowered so I can make my truck and other payments. That's what this is about, is because you can't live your lifestyle the way you want to do it and still support your family.
Well, and it's not about the truck. I'd let the truck go in a heartbeat. It's the fact that I need a vehicle so I can get to work, so I can keep my job.
Well, but let's talk about that, because Mr. Holly came up here and advised the court that you were living with your mama. And that's what you had told him. Again, don't answer that question because that's attorney-client privilege. But again, that statement wasn't true. You're living up with your girlfriend, aren't you?
I'm back and forth in between my mom's house, my parents' house, and her
Where'd you
house.
spend last night?
In Waverly with girlfriend.
And where'd you spend the night before?
My parents' house.
At your parents' house?
Yes, ma'am.
Because what, you had to go do the MRI and somebody, and your mama carried you and paid for it? Is that right?
I'm sorry, say again?
Why'd you spend the night with your parents?
That's my other home.
Your other home. And you were out riding around in the rain with a friend. What friend were you riding around with?
Richard Lindsay.
Richard Lindsay. Now, you and Mr. Lindsay had a little bit to drink, hadn't you?
No, ma'am.
It's your testimony here under oath, under penalty of perjury, sir,
I understand.
that you had not drank anything on the night of your wreck.
No, ma'am.
You had not.
No, ma'am.
If you please state, I had not drank any alcohol on the night of my wreck. Would you?
I had not drank any alcohol on the night of my wreck.
Okay. Had you taken any non-prescription medication?
No, ma'am.
Or let me rephrase that. Any non-prescription medication that was somebody else's prescription?
No, ma'am.
That's your testimony.
Yes, ma'am.
Did you seek medical treatment that night?
So it was late night, early morning, and no, I didn't, because I wasn't going to be out of the emergency room in time for me to make my anger management class in Franklin, Tennessee, that I had to be there at 8 o'clock in the morning for.
Okay. Well, what time was the wreck?
It was probably a little bit past 1, 2. I'm not sure.
1 or 2 in the morning?
Yes, ma'am.
What you doing running out and around? What night of the week was this?
Friday.
Friday night, and you knew you had to go to an anger management class,
Yes, ma'am.
and you were out riding around with friends in the rain until 1 or 2 o'clock in the morning.
The reason I left was because of the rain. The rest of the night had been perfect.
Well, so you had money to ride up and down the roads. Where'd y'all go?
We just rode around Humphreys County.
And it's your testimony here under oath. And again, you know Humphreys County's a pretty small place.
Yes, ma'am.
A lot of people know a lot of people around these parts.
Yes, ma'am.
Okay, and it's your testimony you didn't stop anywhere?
Gas station, maybe?
Didn't stop at a bar or an establishment
No,
that had alcohol?
No.
Didn't go into a gas station to buy beer?
No, ma'am.
Sure about that? Okay. And what time did y'all start this riding around junket that you were on?
I'm not sure, to be honest with you.
Not sure. Don't know.
No, ma'am.
But you went back to your girlfriend's house
Yes, ma'am.
and wrecked in the pine needles
Yes, ma'am.
and didn't seek medical attention.
was the time, and I don't know.
It's pretty simple. Did you seek medical attention that night? Yes or no?
It was later on that same day.
After you went to your anger management
Yes, ma'am.
11-hour class?
Yes, ma'am, because if you miss one of those, it's like 3 months later before you can make up that class.
What does your girlfriend do for a living?
She's currently unemployed. She's high risk pregnancy, and they recently laid her off until the baby's born.
Did she work before that?
Yes, ma'am.
Where'd she work?
She's a CNA at AHC here in Waverly.
Okay. Where's she living?
In Waverly.
At volunteer, right?
Victory.
Victory. Right there, just close to where you work.
Yes, ma'am.
So how in this income and expense statement, although it's not listed in there, how are you spending $700 a month on gas?
Because my truck gets about 10 miles a gallon.
You got you a motorcycle? Her house is about less than a mile from your plant, isn't it?
So, and I just now got that motorcycle where it was able to be driven safely.
Well, what was unsafe about it before?
It had wires showing in the back tires.
Well, so you've had money to fix a motorcycle for you to go joyriding on at 1 and 2 o'clock in the morning?
That money had been saved up over time because those tires I needed to get for a long time. And the goal of that was to cut down on the gas mileage of the truck.
Well, let's talk about it. So you were able to get tires and stuff on yours that you replaced. You flattened her tires, didn't you?
As I see that,
Did you flatten her tires, yes or
I
no?
believe it.
You plead the fifth.
As I feel like that may be related to my criminal case, I plead the fifth.
Okay. Well, you know the text messages where you apologized for it. You wrote that, didn't you?
Again, Judge, I would ask you to remind him of his Fifth Amendment on any of that.
I don't need to remind him. He's already exercised his Fifth Amendment rights. As I've said many times, a person who in a civil proceeding refuses to answer a question because they invoke the right under the Fifth Amendment, that's saying essentially that I decline to answer the question because my answer could possibly inculpate me or incriminate me in criminal activity. So there's an inference that can be taken by the court that refusal to answer a question means that they are guilty of some misconduct. So he's exercised his right under the Fifth Amendment. I don't need to tell him every time. He knows what his rights are.
Did you send an apology text message for what you did to her tires?
I plead the fifth.
Okay. Did you buy her new tires?
I plead the fifth.
You did not buy her new tires, did you? But you got new tires for your motorcycle.
Judge, again, I would object. That's been asked and answered. But
It's a different.
Actually, it's a compound question. She asked, first of all, you didn't buy tires for your wife. You bought your tires for your motorcycle, which is really a statement rather than a question. Sustained as to the form of the question.
How much did I'll rephrase, how much did your motorcycle tires cost?
$110, I believe.
How much did all the repairs getting the wires cost?
The wires were in the tires, so
Okay, the wires that you had, where was that money saved up at that you spent to do it?
we're working overtime.
Now, where was it physically located? Because it wasn't in the bank, was it?
It wasn't the bank.
What bank account was it in?
Discover account,
Whose names was on that account?
my account. And
Your wife had access to it to pay for your children?
No, ma'am.
Why are you having another kid when you can't support the ones you already got?
I haven't supported them.
Well, you're asking to reduce it so you can pay your truck payment and live the life that you want to live with your girlfriend.
That's not necessarily true.
Not necessarily true. But what is necessarily true about that stuff?
That I was trying to have it drop so I would have transportation to work and be able to buy food. If it wasn't for my parents, they had fronted me so much money, and that's what I've had to go on for.
But you're going to get short-term disability that makes you whole. You're going to get the exact amount. You're going to get more money than what we calculated your support on before.
But I don't have that now, and isn't that what this motion's for? So,
You're going to get back pay, aren't you?
yes, sir. Yeah,
So you
yes,
can-
ma'am.
So you can pay those people back. So what your kid's supposed to do, because you was out joyriding at midnight, what your kid's supposed to do to get food on the table, sir?
I can assure you the support system that she has for my family, those kids will not go without.
So it's your family's responsibility, so you enjoy riding, pregnate other people while you're married to this one.
There's a little Jack, that's all.
I'll withdraw the question, Your Honor.
He's rephrasing it.
Order protection's in effect. You haven't completed your anger management, correct?
Correct.
You still have criminal charges pending.
Yes, ma'am.
And again, you've gone through this because the allegations in those criminal charges are true.
I'm sorry?
The allegations in which you were charged with are true, are they not?
No.
They're not. You didn't try to lock your wife out of the house, lay hands on her, do things like that.
I plead the fifth.
You plead the fifth. You gonna tell me what transpired that night when the police were called?
I plead the fifth.
But you left and went to your girlfriend's house, didn't you?
No, ma'am.
Where'd you go?
To a hotel?
To a hotel?
Yes, ma'am.
Did you take a loan against your 401k?
Yes, ma'am. Before the divorce was filed,
How much did you take out?
it was 17,000.
Where's that money? That was just at the beginning of this year?
I believe so. Yes, ma'am.
Where's that 17,000?
It went to lawyer fees.
Lawyer fees for your criminal charge?
Both. Yes, ma'am.
You put on your income and expense statement. May I see the one? Did you have the one in your
Oh,
hand?
yes, ma'am.
May I see that? Is all this true and correct to the best of your knowledge?
Yes, ma'am.
Okay. What is this, $228 for choices?
That is currently the anger management. That's the courses that I'm taking.
And you're paying $228 a month for those
Per class, yes, ma'am.
per class?
Yes, ma'am.
And you have documentation showing you paid that?
Yes, ma'am.
Then you're paying $53.80 for 84 for therapy? Is that right?
Yeah, yes, ma'am.
And you're paying that?
Yes, ma'am.
And you're gonna show me a check stub or a
Okay.
receipt where you did it?
Yes, ma'am.
And $107.68 that you said you're paying for your kids?
Yes, ma'am.
And you paid that?
Yes, ma'am.
You know any reason why they're calling her and saying that payment hadn't been made?
I can show receipts for that.
But you paid it every time and there's not a delinquent balance?
There may be. I'm behind on a lot of things, but it has gotten paid and
Yep.
been current.
So you're sitting here today saying that that payment is current, yes or no?
The last time I was there, yes, ma'am, it was.
I didn't ask if it was the last time you were there. Today, is it current?
I probably owe the one balance.
How often you go to the beauty shop or barber shop for $60?
Once or twice a month.
What prescriptions you're on for $30?
I've got blood pressure medication. I've got anxiety medication. I've got Lexapro for depression.
How long you been on it?
I believe since November of last year.
You understand on Lexapro, the anxiety medicine, you're not supposed to drink,
Yes, ma'am.
but you're drinking with them, aren't you?
No, ma'am.
You sure?
I plead the fifth.
Okay, well, which one is it? No, ma'am.
No, I have
You
not.
said
done-
no, ma'am first, and then I said, are you sure? Because you understand you're under oath under penalty of perjury. And then you plead the fifth. So did you lie when you said no?
Plead the fifth.
That's all, Judge.
Redirect.
Judge, the contention in Ms. Roberts' cross-examination, I would move the income and expense statement to be put down. That's all I have.
All right. Mark it as Exhibit 1 to this
Mr.
hearing.
Holly, he's wadded that one up. Holly, you got an extra one or something you gave, because it's, yeah, I got it. So I mean, just, your client just wadded his up. Yeah, that's
That's good. Swap that out.
Anything further for this witness? you, sir. You can step down and have a seat by your lawyer. Holly, you have any other proof?
Oh, his mother, what's her name? Jennifer Thomas.
Raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you, ma'am. If you'll come around and have a seat.
If you will state your name for the court.
Jennifer Thomas.
Ms. Thomas, you have a good relationship with Ms. Hinton? How would you describe your relationship with Ms. Hinton?
Very close. We have been from day one. I refer to her as a daughter-in-law versus a daughter-in-law.
What's your relationship with your grandchildren?
My grandchildren are our world. We have a good relationship. We spend a lot of time over the years from day one. Since the first child was born, they lived with us at least 8 months for some time, and the relationship has just continued to grow. Have spent a lot of time at our home with us, and they're the center of life at this point in my life.
So have you been able to see the children at all this year?
I haven't seen them as much as usual due to circumstances. I need to understand where they are very active in sports, and they've been very busy, which I understand. But in the same topic, I've been able to see them in attending events. I'm always, kept up to date on when ball games are, school programs, etc. And I can see them. They have not been overnight guests as much as before this all started.
Are you able, if the judge orders for you to be there for the children, if your son, Stefan Hinton is your son, if the judge does see fit to allow some visitation, wants it to take place at your home, are you available to be there, to supervise if necessary, or are you willing to do that? If something goes south, are you willing to call Ms. Hinton or the authorities or whoever you need to call to make sure that it's corrected?
Yes, there's no danger, and I think that our home could be considered a safe place for the children. My husband's in law enforcement. I don't think there's not an issue with anything criminal, criminal activities taking place.
What does your husband do?
He is the assistant deputy
Oh, what center?
detention center.
Detention center. How long has he been doing that?
He's been in law enforcement since he retired from the military. He served 20 years in the Air Force. And he's been, I believe, retired for 6. And he's been in law enforcement since he turned 65 years.
Okay. Is this Mr. Hinton's father or stepfather? Okay. And is he there every night with you? Okay. What are the children's demeanors when they're with you at your home?
Our home is always the place of good times, good fun, good times. We always have to have a great time. This has happened. We haven't had, there hasn't been any change in their demeanor as far as when they're at our house. We continue with life as, they know it when they come to Hinton and Paul's. Play outside, TJ and boys, working on cutting wood, and they ride the buggy, which is a side-by-side utility vehicle. Visit pigs. Most of the time, two cousins of theirs are there with me. It's just a good time had by all.
That's all I had.
Robert?
Ms. Thomas, where is your son living? He lives at your house, stays there every night.
He's in and out.
Well, percentage-wise, he's actually living with his pregnant girlfriend, isn't he?
He does stay there something.
He stays there how many nights a week?
Hard to say. He's in and out of my house.
He stays very rarely and spends the night at your house, isn't that correct?
He's not there.
Okay. He's actually living with his girlfriend.
His address is 193.
Didn't ask what his address is. You understand? And again, you have been a good support to her, and I don't want to do anything that's going to affect that. But your son is living with his girlfriend.
His name's Darryl.
Okay. He'll come to your house occasionally. But again, where he's staying most every night is over there.
Judge, I'm
Isn't
going
that
to ask and answer to repeat questions.
I think she is his mother. Understandably, she wants to try to put him in the best light for the court. But, and I'm not going to hold it against him. If he's staying the nights at his girlfriend most of the nights, but just comes occasionally with you, that's really that's all the question is. My decision about him seeing these children is not going to be based on whether he's actually living with his girlfriend or living primarily with you. I just need somebody to tell me the truth of the situation. So
He has spent the night. He does spend the night down there, and he does occasionally spend the night.
occasionally spending the night at your house is not the same as living there. So that's all we're trying to. He lives primarily with his girlfriend, stays occasionally at your house.
Yes.
And again, Ms. Thomas, the reason I'm asking that question is these kids, you understand your grandkids are in therapy.
Yes.
Primarily because of the events that's transpired in their lives between their parents. You understand, do you not, that your child, your son, started having an intimate relationship with your daughter, your granddaughter, who, how old is she? How old's your granddaughter? She's 8, and she was involved in this cheerleading kind of thing. And her coach, who most kids revere and respect and look up to, he's having an affair with her coach, who she's friends with her daughter. You understand how that would make an 8-year-old feel that daddy left mama for my friend's mama?
It's heartbreaking.
It's heartbreaking, especially for an 8-year-old to process. And the scenario about where he's living, if he's all up in your house, living there supposedly, you can see how that may cause stress and strain to your granddaughter. And if anybody would just tell the truth and say, no, daddy's staying over there and this isn't his house, and this is a safe haven for you, young lady, and my grandson and my granddaughter, this is safe for you because this has always been your safe space instead of daddy's. That would have an impact. But neither you nor your son could just tell the truth and say, no, he's living over there.
I do consider him to be in both places. And fair enough, he is there, and if he does come to my house, he's safe.
Some too.
Yes.
But the focus is not him in this situation. Maybe he's put the focus on him, and that's why his marriage is failing, and why he's got another woman pregnant before he gets rid of another one. But don't you agree the focus should be on what's best for these kids and not what's convenient for him and, oh, this, that, and the other? He's going to have to make a change.
This, as I've stated before, this is not my business. I am in the middle, and I love it.
But do you agree that your focus should be more on your grandkids than on your son?
They are my focus. But in the same retrospect, I love them.
And don't want that to change.
And I want the best for them because everybody loves them. So,
But again, the kids are in therapy. she's carrying them to therapy to deal with these issues. But there was an instance of domestic assault. Your son's been charged with it. He's going through anger management, paying a bunch of money to go through classes. He stabbed her tires and flattened her tires. You were aware of that, weren't you? He admitted that to you, didn't he?
Judge, I would object to the relevance. I mean, we're not here for the criminal case. We're here for the visitation part.
You don't think somebody slashing the tires of his wife is relevant on the issue of what kind of visitation, if any, he should have?
Well, by and large, what he said about it or whatever was done.
What he said about it would be an admission, since your client has taken the Fifth Amendment, to refuse to answer the question, then that the question of whether or not, there's obviously implies that there's something about that would implicate him in criminal activity, but it is not protected from her testifying about a statement he made. So overrule the objection.
If I may, I would just.
You're overruled.
Did he admit that to you?
He told me that he did prevent her from leaving the cards, and he did replace the cards.
But he was angry that night, got mad at her. He locked her out of the house first.
I wasn't there.
Kids were in there.
I wasn't there.
Stabbed her tires so she couldn't leave.
I know that he couldn't see. He made it where she couldn't move, but I didn't know she was. There's been a lot,
Been a lot. And these kids need time to process, don't they?
I feel like it's been almost a year. And that, I think children deserve to have both parents. And I do believe he's worthy of being. And I feel like if we grant him some information, that our home would be the best place for him.
So again and again, I don't mean this disrespectful because this is your son. But you're still looking at it from his perspective.
When I say our home, that's my husband and myself.
That's all.
Anything further?
No, Judge.
Thank you, ma'am. You may step down and have a seat. All right, we're going to I assume you're going to have some proof as well.
I would move to dismiss, but again.
I'm going to overrule your motion to dismiss. I'll hear any proof after lunch. We'll take our lunch recess now until 1 o'clock.
Thank you, Your Honor.
All right. All right.
All right, Ms. Roberts, you have any proof you wish to offer?
Yes, Your Honor, I call Ms. Hint to the stand.
Will come up, please.
Ms. Hinton, you have two children with this gentleman.
If you will stand and raise your right hand, let's place you under oath. You stand up.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth?
Oh, thank you. Now you can sit down.
You're Talisa Hinton, is that correct?
Yes, ma'am.
Ms. Hinton, you and Mr. Hinton have two children. What are their names and ages?
Gabriella Lucia Hudson, she was 8, and Stephon Pollard,
And what grades are they in?
3rd and 5th.
And you and he live together here in Humphreys County, is that right?
I mean, the kids?
Yeah, well, y'all live together here in Humphreys County as a family.
Yes, ma'am.
Okay. And at some point in time, y'all separated, is that right?
Yes, ma'am.
Tell me about the events that led that up to that. Did you have to get an order of protection?
Yes, ma'am.
Tell me what happened.
This goes back to December 9th. I recall that day there were storms coming in. We went right over. We weren't even watching. I was at home with the kids by myself. It was a Saturday. And sirens are kind of going off on TV, keep an eye on the weather. My kids have always known that whenever weather gets like this, kind of go to the hallway closet, in an enclosed area. And so my daughter that day was freaking out. This was the first storm where it was just us 3. and she had made attempts to call her dad on FaceTime because they tried their phones, and it was Wi-Fi call through. And she had tried calling him, he wouldn't answer, and he ended up calling back on audio, and she was asking how.
And you heard this.
Yes, she was on my lap at the time. We were sitting on the love seat. She was like, "Dad, where are you?" She's like, "I'm scared." She's like, "We're here." And I told her that he was gone. And he started getting upset with her, or not with her, but kind of upset at the situation because she was upset over him.
She wanted your daddy.
Yes. And he basically was saying that this was my fault. I didn't want them in there. That's why they were there. And that he was going to see her soon.
And prior to that, you had found out he had been having an affair.
Yes.
And who was he having this affair with?
Alexis Garcia.
And Miss Garcia was a cheerleading coach for your daughter, and with local junior pro team. Kind of caused a whole ruckus with that, didn't it?
Yes, I ended up pulling her.
And did your children, in particular your daughter, was she aware of their, or kind of as a go-between in that relationship?
I don't think they fully understood it, but they knew something was wrong.
So she had to quit her cheerleading.
Yes.
Did he move out?
Stefan was still living in there.
He was-
But he would get to the point wherever he get off work at 3:50, and he would get home, shower, and then be gone before I would get home. I would get off at 4:30, go to my nanny's house with the kids. That's right from the house. By the time I would get home, it's roughly about 4:45, 4:50, he'd be gone.
You worked for the city of New Johnsonville Court
Yes,
System, is that correct? Now, and did you find out that he was going to this lady's house?
Yes.
And we can pull out the pictures if necessary, but he's already admitted he's having an affair, so, he wasn't home with the kids.
No.
And how long would he stay gone?
He would sometimes stay gone for days. Just basically come home, shower, get his stuff at work, and then he would leave. Always next morning.
And then, so this storm came up, and then did an event happen to where there was an altercation that occurred that caused you to call the police?
Yes, ma'am. So we heard his truck get outside. Our living room's not that big. We have a long couch, and then we have the love seat that's right next to the wall. Me and Gabby were on the back on love seat. She was on one side, I was on the other side. We had been watching a movie after they calmed down, and Stefan ended up coming in the living room and went straight to her. I kind of just glanced over and just ignored it. I didn't say anything. I just kind of went back to my phone. He asked me if I could get on my phone. I told him no, I wasn't doing it wrong. The way he was sitting down, his head was kind of in Gabby's lap. He kept saying things like, "Get off your fucking phone." I was like, "Oh, I'm not doing anything." From that moment, he was upset. So then he started getting up, and he was just mad. You're a bitch. He's going to fault.
Where's your son at this point now?
He's laying on the couch.
So this bitch and all the fuck off the phone, all that stuff was in the presence of your children.
Yes. So he kind of storms off. I kind of look over at Gabby. And I'm like, well, he ends up calling her. And she goes in there and takes her outside. So I ended up following her. And by the time I get to the door, she's running back in, and I'm looking at him, and I'm like, "You're gonna be here." I was like, "Don't be starting." Stop. I was like, "The kids will be fine all day."
Don't be throwing. What did you say?
I said, "The kids have been fine." I was like, "They
Okay.
said over the storm." I was like, "They're okay now." As for shit, he pushes them back. You didn't realize that Gabby was standing in the doorway of the kitchen living room when she saw it. So she starts crying and screaming. My son at that time was in the living room, laying on the couch. He came in and stood between us. And Gabby's hysterical. She's like, Daddy, why? Why would you do that? And TJ is asking questions like, what is going on? Well, I keep telling him to leave. They don't want to leave. And it goes to where he says, I just wanted to ask Gabby a question. So I look over at Gabby and I'm like, what did Gabby ask? She's like, I wanted to do that.
Judge, I'd object to the.
Okay, well, let's not talk about what Gabby's,
Sustained.
okay.
So he ends up getting mad. Like, fine, I'm leaving. He's going back and forth. He's trying to gather his things. And both of the kids, he makes a comment of,
You can say what he said.
something along the line, you're gonna find out or what's gonna happen. And well, Gabby kind of hears that. She starts crying even more. He gets out the house, then says he forgot his keys, comes right back in, and this whole time my son TJ is standing in front of between us. Before Tyler leaves, I have a glass tea container. It's about maybe this big. And he grabs it and just throws it across the wall and then walks out. Both of the kids are in the kitchen in the house, and they're both freaking out. And I end up just going, locking the door, and going straight to console them. So that's basically some of it.
Okay. Have there been prior occurrences where he locks you out of the house?
Yes.
Okay. Were there prior occurrences where he stabbed your tires and flattened your tires?
Yes.
And where did your kids see all that?
No, but they did not see that because I didn't see the.
He didn't see, she didn't see, he didn't see you, they didn't see him slashing your tires.
Yes.
But did they see, was there an altercation going when he locked you out of the house and wouldn't let you come back in?
He was upset because at this point I was in my life works. And I remember him going in and locked me out. And I remember calling his parents. I remember speaking to his stepdad. Oh, I'm calling my house as a kid. Like,
They came over.
no, they did not come over. This was just over a phone call.
Okay. And were your kids there when you were locked out of the house in the
Yes, they
street?
were inside.
Okay. So they've witnessed some trauma, but it wasn't just one isolated instance. There's instances when they've seen that and actually seen their dad lay hands on you. Your son has gotten in between you to protect you. You're in counseling with who?
Hometown health care.
Okay. And you're carrying them.
Yes.
And do you think that introducing their father back in at this point in time is good for their mental health?
Judge, I would object. The call's kind of.
I'll rephrase it. I'll rephrase the question.
Any objection?
Do you think it's best for your children to be reintroduced and start having visitation with their father right now? Think when the therapist starts some therapeutic reunification, I think would be great. Now, you have a great relationship with your mother-in-law. Do you want to put her in a position to where your children see that she's kind of a safe place for them?
I expressed to her sometime last week that my daughter is the one that's not struggling with the move anymore. She doesn't feel comfortable.
Do you want to preserve the grandparent-grandchild relationship?
Yes.
Okay. Do you think putting her in the middle may affect that relationship? Because again, she's having to monitor the son, not be grandma to them, do things like that. You just don't want to put her in that situation, do you? And you'd like the order of protection to stay in effect the way that it is, and the children be protected until such time as a mental health care professional says that it's time to be reunified. That's all.
Mr. Holly?
Yes. This had reached out. Oh, but listening to some of your testimony, you pulled them from cheerleading, correct?
Yes.
And Mr. Huns admitted to the affair, correct? And he admitted it to you as well as in all the pleadings, correct? It's fair to say you guys were having some marital difficulties?
We were perfectly fine. until I found out about it. As to my knowledge.
Also, when you said that, your son's name is Gabe. What's your son's name?
Stephon.
Stephon.
He goes by TJ.
TJ. Said that, when he shoved you, or the allegation was he shoved you, that Mr. Henry really didn't realize that there were any children there watching, any of your children were watching. Is that accurate?
Yes, because as soon as I hit the ground, my daughter started screaming. My daughter was in between the kitchen and the living.
You're saying that, alleging that he had stabbed your tire, slashed your tires. Had you slashed any of his tires? Not done any sort of damage to any of his vehicles at all? Or the vehicles that he drove, they're y'all's vehicles. But any of the vehicles that he drove?
I'm not slashed.
Have you done any damage at that time to any of the vehicles that he drove, the motorcycle or the truck or anything?
I cut the seat, but one side. No, twice.
So fair to say it's kind of a tit for tat type thing. So yes.
Whenever your husband is supposed to come home, and then you find out that he's out having an affair, telling the kids one thing, and then doing the complete opposite, and putting you in the middle, and making you seem like a bad guy.
I understand what you're saying. I mean, but again, you wouldn't have conducted yourself in that behavior if you're telling me he wouldn't have conducted himself in that behavior. Is that fair enough?
I did. I'm not denying it. I did slice the seat. That is the only thing I've done.
Fair. As far as the counseling and everything goes, he's paying for that, correct?
Yes, I'm pretty sure in the last quarter, this is where he wanted, chose the counselor. And that was fine.
As far as you know, there's Roberts. They really questioned him about it, and of course, you know, they're still able to go to counseling. There's no issue with payments or anything like that. He just kept that payment up, correct?
I've had a few calls, but they won't speak to me. I'm not Stephon.
Are the kids still going to counseling, or they've been turned away for non-payment?
No, but this past, I told Ms. Roberts that this past month, my son had pneumonia and my daughter was sick too. So that led on one of the therapy days. I had to take off of work for 2 days.
And you work in New Johnsonville
Yes.
at the police department?
Police
Clerk's
department at
office?
City Hall.
Okay, City Hall. What do you do for them?
For City Hall, I'm
Yes.
a court clerk. And then for the police department, I just do all their tickets. All their administration.
And what's your hourly rate of pay?
17.
You work 40 hours a week? Sounds like you and the mother-in-law, your mother-in-law, get along really well. Is that fair enough? I mean, do you trust her with being able to communicate with her and her being truthful with you?
I would hope so.
They have a moment, Joe?
You may.
Is there a time that you had taken the wrenches, some wrenches, and thrown them at his truck, causing damage? Thrown anything at the truck that could have dented it?
I recall a situation back whenever his affair had started. He said that he had some dents in his truck. I told him, I was like, I don't know that.
Okay,
I wouldn't know what happened to it.
fair enough. That's all I had, Joe.
Do your children know he's about to have another child with this paramour? What types of physical manifestations have you witnessed that they have when they deal with that issue?
I would object. That's outside the scope of my cross-examination. I never asked about it.
Sustained.
That's all.
Let me ask you a couple of questions. Make sure I'm understanding. The reasons you feel like that the children are so traumatized is because of that one incident that occurred where he threw the glass container and broke it and shoved you and you fell.
From the point of when I found out there, I think in December, Stephon was never home. We quit going to our son's football games. And before this, he wasn't involved in because we were a family full.
Okay.
We did everything together. But whenever that started, we were showing up to practices, we were showing up to games. And it was always, he was drinking. And he would get upset and it was just escalating.
Part of what I have to do is to balance the best interest of the minor children with the parental rights that both you and the father of these children have. One of those parental rights is the right to have visitation unless there's some overwhelming, or not overwhelming, but some justifiable reason to deny visitation. Clearly, there was an agreement that was put down earlier in this case, and now I'm being asked, it was not one I approved, but I'm being asked to change that. So what I'm trying to find out is that why do you honestly believe that it would be harmful to your children to have any sort of contact with him, no matter how short or how slight? Normally what we would do is we would implement a graduated schedule where we're reintroducing a parent who's not been around, and sometimes it is supervised visitation. But are you telling me that in your opinion, you feel like any kind of contact with at his mother's home, even for an hour or two at the beginning, would be harmful to your children?
We had one in COVID at Walmart. This was a few months ago, where it was me and my daughter and had a young cousin with me. And we were walking into the class. I did not realize that he was there. We went, as we were walking into Walmart, he's kind of going through produce, and my daughter stopped straight in her tracks. And she looks at me, she laughed and
Judge, I would object to your hearsay.
Overruled. He's answering a question that I've asked, and I will consider that information. Just if it's not being introduced, the statement was I have to go to the bathroom. Well, if it's being introduced to prove the truth of that she went to the bathroom, that she needed to go to the bathroom, that would be hearsay. That's not the reason it's being introduced. So for that reason, I overrule it. So who is this therapist you're saying? Of the children?
The hometown health counselors.
Does they see one particular one?
Yes, they each have 30-minute sessions.
Have they give you any report about what the progress is with the children?
She's told me that TJ, which is my son, that he's angry. He doesn't want to see his dad. He's upset of everything that's happened. My daughter is more upset about the whole concept.
All right. Anybody have any questions for her based on what I've asked?
Did you say it's a Miss Hale?
Yes,
That's the counselor, Miss Hale with the,
hometown health.
and is she also counseling, to your knowledge, with,
TJ?
uh-huh,
She does both of them.
right, she's doing the counseling for
Yes, they
both.
each have individual solo sessions.
But she's in a unique position to know where he is in his process and where the children are in their process.
I'm not too sure if he does stuff on.
Okay.
I know she does
The
both
two.
of the kids.
But he goes to that hometown.
Yes.
That's where he's going to therapy too. We're supposed to be going to therapy. We didn't see any proof of that. Again, there's a court order. He entered a plea. If I could approach, you can see his plea sheet. You were discussed, not exactly what it was, but were you in court when you entered in an agreement with the district attorney general and entered a plea?
Yes.
Okay. In that plea sheet, his case is reset to be dismissed in a year if no further charges, completes a 12-hour domestic violence class and anger management classes for 12 hours. therapy is already scheduled with Hometown Health Clinic in Camden. Okay, so he's ordered to go to therapy. And then it goes on to say, bond conditions to remain in place unless and until modified by court order, agreed, or otherwise. That's what he agreed to downstairs on the criminal charges. But we haven't gotten any report about how his therapy's going. There's been no proof they've rested their case about the therapy that he's doing. And you agreed for the kids to go down to the same place he was going so that there could be some type of therapeutic reunification, correct? And that's what you're thinking is best for them at this point in time. Your Honor, we'll move this into the next exhibit.
Look at this exhibit 2. Anything further?
Your Honor, that's all.
All right, thank you, ma'am. You may step down. Robert, do you have any other witnesses?
No, Your Honor.
Mr. Hawley, you have any rebuttal proof?
I do not.
I'll hear you an argument.
Briefly, the income and expense statement that we submitted with him being off work, no question about that. He is off from work. He's not getting paid right now. There needs to be some sort, and we're asking for some sort of leniency on these two, child support and spousal support, until his short-term disability starts. Yeah, there will be a back pay, there will be all of that, but he may be a little late or untimely on some of the payments or whatnot. That's pending that he gets his short-term disability. If not, he'll have to go and do whatever he can do to make a living, obviously. It's a situation that he's in. And if you look at the income and expense statement, he's down $782, and that's with him paying what he's supposed to be paying, making his 40 hours a week. So, we're asking for some adjustment for the $782 that even keeping up with his payments like he's supposed to, and this doesn't even include him if he were to go live somewhere. He's fortunate, that he does have somewhere else to live, I guess, whether he believe he's at his mother's or at his girlfriend's, he's not having to pay any rent. So,
Want me to believe his mother or believe him?
well, if you believe is whatever was testified about him staying at his girlfriend's or staying at his mother's, he is staying at one of those two places. His testimony was, as his mother's was, they're in and out. So he's staying at both places.
Neither place is he paying rent, though, correct?
There is nothing in his income and expense statement for rent. So that's not even included in something like that. So we don't even have that to be concerned with. A lot of people come into court, and I say that because we try to find a place in the road, put all of that in their expenses and things of that nature. He's not doing that, so that this money for rent, utilities at a place, and all of that can be afforded at his, or better process with his children and child support. Or even there, he's $782 behind, and that's if he was making this. He's not. So we're just asking for a stay, and we'll see what his short-term disability is, and he can start that back up and make the back payments if, in fact, that is what happens. There's no issue with that at all. Try to anyway. But again, he is down close to $800 with it. Secondly, we'll see his children. Holidays are coming up. I think everybody, the mother and grandmother here both agree that they can handle the visitation. It can be supervised. Everything that you've heard, I think, more or less is the contentious part of the divorce, and I get that. He did have an affair. He hadn't lied about it and tried to hide it. If you look at the pleadings, it was admitted to from day one when we first walked in and filed the paperwork and the answer to the counter complaint. It's there. And I understand that people are a little contentious when that happens, and there are some very hard feelings on this way and that. And that doesn't affect the children. I think from the grandmother's testimony, hopefully you can glean the fact that she can take care of what she needs to take care of, and the children will be safe. Obviously, with her husband and his stepfather, who's a pretty solid guy, been in law enforcement for many, many years, and apparently holds a very top position over in Montgomery County in law enforcement. There's not going to be any hoorah over it. Sounds like more or less the farm of the grandmother's children. There's not going to be anything going on there. He's not going to allow for it.
Law
Your Honor,
enforcement people.
where do we get the, there's no proof whatsoever. This man's not even here. How do we know, number one, what hoorah? that he's gonna keep down. This man's not here and saying he's gonna do something.
Well-
It's totally inappropriate for Mr. Hawley to be arguing.
She testified of his background, and that's what I'm referring to.
I think this is argument that's not evidence, and the court is aware of the fact that Mr. Hawley, like I am, have known many law enforcement officers in our past years. And there are many fine officers like our bailiffs here, and then there are many officers who sometimes let things get out of hand. So it's just because a person is a law enforcement officer does not give them a halo above their head that would say that they would never allow anything to happen. But I understand the argument you're making.
Apparently, he's been in law enforcement for many, many, many years, and holds it.
I've known officers who have been in law enforcement many, many, many years, and I would not let them babysit my children.
Well, anyway, Judge, we're asking for some visitation. The holidays coming up, and what we think is fair is to put her parenting plan in play at this point. It's what she filed originally. If it needs to be supervised at his mother's, then let it be supervised at his mother's. But that's what we're asking for. There's no reason why he can't see his children. I understand the parties don't get along, but there's no reason that he can't see his children. I'm sure they're missing him like he is.
No reason other than the fact that there's a court order down that he agreed to that stops him from seeing the children. So,
Well, that was pending if I may, Judge, that was pending the domestic and some things we had to work through. I knew better than to have a hearing at that time because, yeah, there were a lot of question marks and we didn't know how that criminal case was going to fly. And nowadays, we know now that it was reset to be dismissed and things of that nature. So it's not like, and I would submit the gentleman this morning while he's incarcerated for this, for those times. This case is a little different that they've reset it to be dismissed. That was a question mark at the time we were here back in, I believe it was February when we agreed to the order of protection. But since we've done that, he's testified everything that he's done with these classes. And he's got one more 12-hour class to go, and he's going to make that. So I think and I would submit to the court, he's deserving of that.
Roberts, unless you have something really brilliant to say, I'm just going to tell you I don't need to hear anything from you. This is, number one, this is a motion to modify the child support, but the proof has been that his income, when he's on this total disability or limited disability, will be essentially more money than he was making at the time that it was calculated for his support and child support and his spousal support. So therefore, there really is no change of circumstances regarding that. The fact that he's not receiving it yet, but the indications are that he has been, is going to receive it, and there's going to be back pay. So the question of whether or not it would be a situation where he's in willful contempt is a question that would have to be reserved. But I don't find that there's a circumstance that would justify a modification of what he's been previously ordered based on the proof that he's going to have this temporary total disability. And that's aside from the fact that his injury results from him doing something that, anybody might have done under the circumstances. There was no proof contradicting what he said about how the accident occurred. So I don't infer that there was anything that was per se criminal that occurred during that he was DUI or anything like that. But under the circumstances, what it seems to me is that if I reduce it now, and then he gets the total disability, then it's going to go back. Mr. Hawley even made the question, we can then catch back up. Well, that doesn't make really a lot of sense. If I reduce it, then he's not going to owe it. So I'm leaving it as previously ordered because of the fact that the proof has been that, in my opinion, he will be earning about the same or a little slightly more when he gets his total disability. And I'm not necessarily saying he won't be in contempt if he doesn't pay it, but he certainly can show that he had reason why he couldn't pay it. If he catches it up, he purges any contempt anyway. So that back pay that's going to come to him when he gets approved for the total disability should solve a lot of the problems regarding that. And that other issues about how much he owes is really more for the final hearing in this case rather than a temporary modification. The visitation is a stickier issue. I understand what Mrs. Hinton is saying about how the children react. Anybody who grew up in a household where you have a father who's angry or bitter or has outbursts of anger and says things or breaks things, those things stick with you. But and the best interests of the children clearly are that they not be exposed to those kinds of behavior. But children are on a regular basis, and parents, children don't get to choose who their parents are, unfortunately. So they have to live with whatever God's given them as a parent, unless something else happens. So whether Mr. Hinton is a good parent or not, at that point, the law says he's entitled to see the children. The complication is, in this case, that we have children who are undergoing therapy, and as a result of that, whatever order I put down may be contrary to what the therapist says is in the best interest therapeutically for the children, or what Mr. Hinton and his therapy deserves. So I don't like to have to reset matters, but I'm going to set a hearing in this case on November the 25th, next Chancery Day. And on that day, I want to see a report from the therapist regarding the children and Mr. Hinton about that maybe, I don't know if that's before Thanksgiving or not, but anyway, it'll be before, it's right before Thanksgiving. So talk about holiday visitation, we can address that issue. But I want the therapy, I want a therapist report from your therapist that's treating the children to give me that information. Ideally would be for the therapist to be here so that we can hear from them directly. And if they need to do it by Zoom, that can be done as well. What I'm interested in knowing is someone with a professional expertise to tell me if these children are so traumatized that they cannot even be with their father in the presence of their grandmother, or whether some sort of limited visitation. I find it hard to believe that the therapist would say absolutely no contact after 10 months is still warranted, where he's made some progress. So I think I want to hear from his therapist about the progress he's made to show us what he's done so that we can see where we are. And I realize that may or not yet, be a material change of circumstances, but it's not really required for a material change of circumstances on a temporary situation. So I'm looking to find out what's the best interest of these children and balance that with Mr. Hinton's right to see the children. He has every right to expect he should see them, just like you have a right, to have support for them, despite the fact that he may be involved in that. His obligation to pay support is there, and it's enforceable whether he sees the kids or not. But likewise, whether he supports the children or not, he has a right to see the children. We just have to find the right balance of the children's protection from this, as well as the right to see the children. And I would just tell you, I don't know what kind of a situation you had growing up when you were younger, but if you put yourself in the shoes of an 11-year-old and a 6 or 7-year-old child, how?
10 and 8.
10 and 8, all right. I remember slightly in the dark, dim recesses of when I was 10 years old. I remember very little about when I was 8 years old. But I remember being in a situation where one of my parents yelled and screamed and broke things up and everything like that. That's a bad memory to have. And you're creating memories for your children when you do stuff like that. You are traumatizing your children, and they will live with that for the rest of their life. Now, they can get over it if you get your life straightened out like my parent did and become a productive member of society, and you can, they can work through that stuff. Right now, all you've demonstrated to me is that you're not particularly going to win any Father of the Year awards when you do those kinds of things, and then you go out and have an affair with one of the children's, coaches. I don't care whether you did or, no offense to you, but I don't care whether you had an affair, whether you've impregnated her or not, except how it impacts your children. That's the only thing. I'm not judging you because of what you did. I'm judging you as a parent because of the impact it has on your children. And the fact that you've taken up with the cheerleading coach and your daughter's had to drop out, that's not going to keep you from seeing your children, but it's going to be an issue that your children have to work through to be able to have a good relationship with you. I'm very impressed with your mother. Your mother seems to be able to put things aside that's going on between you and your wife and have a good relationship with her. And as a grandparent, I can tell you that's important. She wants to have a relationship with her grandchildren. And she's not going to jeopardize that to protect you. And I wouldn't expect her to. I wouldn't want her to. So what happens from here on out is going to depend on, number two, what the therapist says, number one, what the therapist says, and number two, your behavior, and from this point forward and how you handle it, and a way to find some sort of a solution that allows us to come with a solution that will protect your children, give you the right to see the children, but also do so in a way that's therapeutically in their best interest. It may end up being that we have to have therapeutic visitation for you to visit with the children in therapy before you start start having supervised visitation with your mother. So, but I want to hear from the therapist before we go any further. I've made my ruling on that part of the case involving the financial matters. I will reserve ruling on the request regarding visitation until the 25th of November. And I expect to hear something from the therapist, hopefully in person or on Zoom, regarding their recommendations. And if you've got a separate therapist and you have one, get them lined up. Tell them I expect to hear from them. Okay?
Yes, sir.
Issue subpoenas, do whatever you need to do, but they can come in and testify via Zoom. We do that routinely. So. All right. Ms. Roberts, if you will draw an order that reflects it. All right. Stand adjourned.